for Mr. Aaron Vasquez. This is cause number CR 21-394. All right, Mr. Vasquez, your last sanctions court, I ordered you to do 20 hours of community service and you've completed that. Where did you do your work at?
Maintenance.
Okay. And then I also ordered you to pay $100 towards your fees and you completed that. I think the only issue that we have left is that you have a girlfriend, correct?
Yes, sir.
And it looks like one of the requirements is that she needs to take a chaperone class prior to you being able to have contact with your child.
Yes, sir.
And so you understand what the chaperone class is? You
Yes.
understand the purpose of it. So she needs to get that done in order for you to be able to have that contact with your child. And I'm sure that you want that contact with your child, right?
Definitely.
So there needs to be a priority. Either she gets it done or you don't see the kid, or you get rid of her and you see the kid. Make sense?
Sir.
I wouldn't let someone else stand in the way of seeing my child. So if you can't get this taken care of, then you're just not gonna be able to see your kiddo because it is a matter of protection based on what you're charged with. Okay.
Sir, I think Mr. Molly had a class, was it 2 weeks ago, I think, but it was already last minute still. He doesn't have it until August, and Miss Clark said that she was trying to see if I can find another person I can do the class with for her.
Okay. Yeah, keep on working with Ms. Clark, and if she's looking, I know she's looking hard, so you can try to help her as well. Anything that you find, don't do it.
Right.
Let her know about it and see if she approves it.
Right.
Okay, because August will be a long time.
Yes,
If I couldn't see one of my kids until August, I would not be a happy camper.
Yes, sir. I want to be there whenever he turns 1, so that's why.
Okay, good. All right, so you know what you got to do and you're on top of it. So I'm gonna have you come back. June 2nd. Okay, we're gonna do the same thing. $100 towards your fees and 20 hours of community service. Okay.
Yes, sir.
On those fees. Probation, is that or function? Probation. So you'll just pay $100 towards your probation fees. Okay.
Yes, sir.
All right, Mrs. Abraham's got a form for you to sign. It's got your reset date. Cause number CR 25-154, State of Texas versus Christopher Wayne Blevins.
Yes, sir.
All right, Mr. Blevins, I see that you want to enter into a plea agreement to resolve your case today. I'm going to have you raise your hand so I can place you under oath. Do you swear that the testimony you give to the court today, the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Your name is Christopher Wayne Blevins, is that correct?
Yes, sir.
Mr. Blevins, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work that he's done for you?
Yes, sir.
Do you have any questions about anything that you've read over and signed today?
No, sir.
Mr. Schmidt, do you believe Mr. Blevins to be competent to enter into this plea agreement? And if so, that he's doing it intentionally, knowingly, voluntarily, after understanding his legal rights and also the advantages and disadvantages of a deferred adjudication plea?
Yes, sir.
All right, Mr. Blevins, you are charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 1, less than 1 gram. If you were to be convicted and sentenced, that would carry a range of punishment of not less than 6 months or more than 2 years, confinement in a state jail prison, and a possible fine not to exceed $10,000. The plea agreement and recommendation in this case is upon you pleading guilty, state's recommending that the court defer a finding of guilt to a lesser included offense of the possession of controlled substance. Penalty group 1, less than 1 gram. Your punishment, your community supervision would be a period of 3 years. You would have a $1,500 fine, restitution of $180, and the state's agreeing to reject 2 unfiled cases, one being an evading arrest or detention, and the other being a tampering or fabricating with physical evidence. Mr. Blevins, is that your understanding of the plea agreement, which you're asking the court to approve?
Yes, sir.
Mr. Blevins, how do you plead to possession of a controlled substance in penalty group 1, less than 1 gram?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone forced you, threatened you, or pressured you to plead guilty today?
No, sir.
The court will accept the defendant's plea of guilt. Any objection, Mr. Schmidt, to the introduction of the stipulation of evidence?
Object.
The evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
The defense?
No, sir.
All right, court will review the evidence at this time. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. Do have some questions and concerns about whether or not Mr. Blevins is going to be able to meet the strenuous conditions of community supervision, such as transporting himself to and from the community supervision office for reporting and drug testing, community service, so on. Mr. Schmidt, anything? Says he was riding a bike. He got arrested for trace amounts of methamphetamine. Is he gonna be able to come to Canton to meet with the probation officer?
I think that the bicycle issue is temporary. Yes, transportation. Okay.
So, Mr. Blevins, if I approve this agreement, you're gonna be, do you have a job? You're working?
Not at the moment, sir. I've been taking care of my mother. She's on hospice. So, I mean, I do side jobs here and there.
You understand you're gonna have reporting fees, you're gonna have you're gonna be drug tested, you're gonna have drug fees, you're gonna have to go do community service. That's gonna take gas. That's gonna take time and effort. Are you gonna be able to do all of this?
Yes, sir.
All right, the court will approve the plea agreement. The court hereby finds that there is enough evidence to convict the defendant of the offense. The court will defer a finding of guilt, places the defendant on 3 years community supervision, orders that he pay a $1,500 fine, restitution of $180. And the court hereby resolves under section 1245, the unfiled cases DA 2025-516 and DA 2025-515. Mr. Blevins, you're ordered to pay court costs of $290 and reimbursement fees of $535. It's a lot of money. Understand that?
Yes, sir.
You're gonna have to get a job. I understand you're taking care of your mom. I'm sorry she's on hospice, but you're not gonna be able to put all that on the back burner.
I get it done.
Get it done. All right, I'm gonna take you at your word. All right, Mr. Blevins, you hereby remanded to the custody of the probation department. Have you come forward to be fingerprinted with Sergeant Martinez. 25-238, State versus Clinton Ray Tinsley. Any update? Mr. McBride?
Yes, Judge, I think we're gonna put it on the the trial docket. I apologize. He does not want to plea. We've considered all the options and evidence. We've gone through everything multiple times and he'd like to trial.
Very well. And what offer was extended by the state that's been rejected by the defense?
Fine deferred, no anger management.
Yep.
Dropping a terroristic threat, 1245 terroristic threat case.
$2,000 fine, Your Honor. It was BIP instead of the anger management instead of the BIP. Yes.
All right, Mr. McBride, your client understands that once he leaves today and we set it for trial, then that's what we're gonna do. We're gonna put a trial and I'm not gonna allow him to accept this offer after today.
Understood. Understand that?
Yes.
All right, then the court will place Mr. Tinsley on the jury trial docket beginning Monday, May 4th. So, Mr. Tinsley, you will report downstairs. My staff will be there. You won't come into the courtroom. We'll be actually picking a trial that day for another case. So you'll meet with them down there. Mr. West will be down there, the pretrial release officer, somebody from the pretrial release department, and they'll give you a reset date and notice. You'll sign that. And then Mr. McBride's not going to be required to be here because it's not an official court appearance. And once your case gets close to being in the top 10 for trial, then we'll notify Mr. McBride. Okay. So
You said Monday,
Monday.
4th.
Yes, and so you'll come in Monday, you'll sign your reset notice, and you'll do that every month until your case is reached for trial.
On the 4th of every month?
No, not the fourth. Just next week, it'll start on the fourth. It might be a different Monday the next month because my trial weeks change.
All right, is there a time, sir?
Yes, 8:30.
Uh,
8:30. So do you have your notice of appearance slip filled out? We'll need to have that filled out. You'll need to sign that May 4th at 8:30. And so stay in contact with your bondsman and pretrial release officer and your attorney. Okay?
Judge, you said 8:30 in the morning.
8:30, yes. And you'll come in there. There'll be a lot of people coming in for jury selection, but Ms. Abraham, my staff will be down there. They'll talk to you. They'll notice, reset notice like that. You'll have a new day. You'll meet with the pretrial release officer, do anything he needs you to do, and we'll get you out of it. Okay?
Sure.